Hello, welcome everyone to March Lunch and Learn. Again, my name is Devontae Roche, counterpart to Linda. Today we're gonna do some lunch and learn, learning about consecutive sentencing, sentence modifiers, which is section 2F and 2G, and we're gonna go over a bit of 2C and 2E. Also, I put in the chat the email address if you want a copy of the presentation. Go ahead and shoot us an email at sentencing.guidelines@state.mn.us, and then we'll be able to send you that presentation. And then also, if you missed our last Lunch and Learns, it is on our website under education and training, and then it's under training videos, and then it's called on-demand lunch and learn videos. So definitely if you missed those or you want to review those videos from the past months, definitely check that out. And then we also have some great educational videos on there as well that you can check out too. All right, so we're about to get started within the next minute here. Some more people come in. Again, I want to thank Linda for doing this with us and taking the time. And then also everybody else, I hope everybody's having a great lunch while they're enjoying this lunch and learn this session. Thank you guys, and listen, have a great lunch.
Thank you, Devontae. We will wait for just another minute and get it started, and we will be recording this session so that it can be posted later. Thank you, Devontae, for mentioning that. If you are seeking CLE credits, continued legal education credit for the lawyers that are out there, we can send you that code as well. So thanks, Devontae, for the introduction. I think we should get started since it's noon. When I did the last training, which was on 2C and 2E, we sort of skipped over 2D, the departure section. When I was doing that, as I was going through and doing those, I realized that so many of those policies that are outlined in 2B and 2E, we call them sentence modifiers, but we don't find them in 2G, the sentence modifiers section. So we are actually going today, when we talk about the sentencing modifiers, throw in a little bit of that 2C presumptive sentence and 2E mandatory minimum thoughts about how we don't necessarily need to worry about whether or not we're in the modifier section of 2G to think about whether there should be a sentencing modifier. So with that in mind, we're going to start first with consecutive sentencing. And before we do, I will remind you that we always use the guidelines in effect when the current offense occurs. So for these policies, for the consecutive sentencing and any of the modifiers, we're on the left side. Guidelines used for the current offense. We want to always make certain we are using the guidelines in effect when the current offense occurs, because when we refer to the current guidelines, we're not talking about the current manual that is lined up with this calendar date. We're talking about the ones that go specifically to the offense date. And those are the guidelines that you then use to find everything related to the current offense, especially within today's training, any modifiers, and also finding the durations for the consecutive sentencing. So we have two different types of consecutive sentencing in Minnesota. We call the first one presumptive, and the second one we call permissive. And when we talk in Minnesota about the presumptive guideline sentence, whenever we're talking about presumptive consecutive sentencing, that is the time that is the presumptive sentence, and any worksheet would be created to reflect that. as opposed to permissive consecutive sentencing, which is a decision that the court makes following the rules that we have. But in those cases, the worksheets are done to reflect concurrent sentencing because that is the presumptive sentence, with the court being able to do permissive consecutive sentencing if they find it, if it is eligible. So presumptive is committed under very specific circumstances. Permissive consecutive is a little broader. But whenever we do a presumptive or a permissive consecutive sentence, and actually anytime we have any kind of a modifier that is going to make the presumptive sentence a commit, so the disposition is a commit, wherever they fall on the grid for the duration, it won't matter in that case if it's a shaded cell or a non-shaded cell. The disposition is a commit. So when we're finding those sentences for presumptive consecutive, we're always going to use the duration found at a criminal history score of 1. And when we go back to that duration, we see that a lot of those boxes are shaded, but because it's a prison sentence, it's available, the range is available for sentencing. So for example, an assault 4th degree would be sentenced to 12 months, commit, with a range of 12 to 14 months. And one of the things that I just want to point out right now, and I believe I pointed out later again, any assault committed in a Minnesota correctional facility in prison is an automatic commit. So whenever we have those, they're always going to be that low severity level 1 usually. So we're in that shaded part of the grid, regardless of what their criminal history score shows. They're going to be a commit and they're going to get the range as well. Same thing is true for permissive consecutive sentencing, but here we go back to the 0 box. And in both of these situations, the commission is not dismissing the criminal history that this person has. They are using these durations to establish a sentence that will be added on to the current sentence or a previous sentence that hasn't expired. So we're not going back to 0 criminal history or criminal history score of 1. We are only using those boxes to find the duration for each of those. So in general, consecutive sentences are applied in 2 different ways. Presumptive consecutive sentencing is when they commit the offense in prison, and the presumptive sentence that should be imposed is a combination of a remaining time on their term of imprisonment plus that duration at 1 added together. Is that going to be more than or less than the presumptive sentence on the grid? So that's always what we're looking for with presumptive consecutive. With permissive consecutive, it doesn't matter if the addition is longer than the grid. It's always just going to be how the court felt it was important to impose it. When the court is going to sentence a consecutive sentence, an offense consecutively prior to an offense that has not yet begun its supervised release term, the court will always aggregate that 2/3 portion, that term of imprisonment together. And then the supervised release that the defendant will serve is going to be the longer of the 2 supervised release terms. The big difference between presumptive and permissive consecutive sentencing is we can speak in generalities about permissive consecutive because there are only two criteria and then the court can impose it. Presumptive consecutive sentencing is very hard for us to talk about in broad terms as hypotheticals. So I'd like to give you a chart that you can use to determine if presumptive consecutive sentencing is appropriate. And then if you establish that the offense is, I'll let you know what information you need to have so that when you reach out to us and we can help you determine the calculation, you'll have everything that's needed. And the reason for that, it is just very broad and it is not always, let me just leave it at that. It's narrow, but it's so broad because it cannot be a hypothetical. We need real solid numbers when we do presumptive consecutive sentencing. So, with respect to determining whether or not it is applicable, the first step is establishing where the current offense occurred. Because the current offense has to occur while they are in prison or while they are on escape from an executed prison sentence, which means because you're already doing a worksheet, if the custody status is assigned as confined or as escape connected to a prison sentence, they meet the criteria. If you're assigning probation or something else, they're not eligible at all for presumptive consecutive sentencing. So step one, establish the type of custody they're under. Step two, again, because you're completing a worksheet with all of their criminal history listed on it, step two is the determination of, is it a presumptive commit? So as we said, all assaults committed in prison are automatically presumptive commits, but not every other offense committed in prison is a commit. So there are times it will be automatic, like an assault, and there will be times when it will depend on their criminal history score. That would be something like introduction of contraband. That is not a presumptive commit by definition, only by criminal history score. So if they have committed an offense that was not an assault, and when you do the worksheet, their criminal history score does not have them in the presumptive commit part of the grid, they're not eligible either. So the presumptive consecutive sentencing is, are they on confined or are they on escape? And is the current offense a presumptive commit? And if it is, then we go to the next step. We apply step two, which is the duration. Here we find it at the criminal history score of 1, and we do this calculation that I've come up with. And it's that, this is a bit of an algebra equation. So when you told your teacher rather that you would never use algebra in real life, I think this might be it, but again, it might just be addition, which is also confounding to me sometimes. But the way that we want to look at whether or not presumptive consecutive sentencing is applicable is whether or not that will result in a longer sentence. So it's a equation of A plus B equals C. A being the time remaining on the original term of imprisonment. B being the duration at the one column of the grid, and C now being the total consecutive sentence that is then compared to the grid time, and the court should impose whichever one is longer. So in my very made up example to show you how it works is to say that 10 months into a 78-month sentence for an aggravated robbery with a gun, the defendant commits an assault 3 in prison. So the original sentence of 78 months had a term of imprisonment of 52 months. So 10 months into that is 42 months left on that term of imprisonment. Assault third degree rather is a severity level 4. They have a custody status of confined, and their total criminal history score is 5. 3 for the incoming, 1.5 for the aggravated robbery they were in for, and 1 for the custody. So we end up with a criminal history score of 5.5, round down 5, and a total concurrent sentencing of 27 months with a range of 23 to 32. So we go back and we say the term of imprisonment remaining for that aggravated robbery is 42 months. The presumptive consecutive duration for the new assault is found at a criminal history score of 1, and that's 15 months. So adding 42 months and 15 months together, we get 57 months. The assault third degree would then be sentenced consecutive, since that math, 57, is longer than the grid time of 27. One thing about consecutive sentencing, especially presumptive consecutive, is the policies do not speak to any credit they have. It does not speak to going back to the date when the offense occurred. So we want to be really careful with this, because there are times when they may commit the offense at the end of their term of imprisonment, and then they get out and they finally go back and deal with the assault that they committed in prison. And now we don't have a term of imprisonment left because they're out. And so one other way that we can approach this that I personally like to do, and that's why I'm sharing it with you, is to sort of change the equation around a little bit and look at the concurrent grid time for the current offense. So in this case, it was 27 months. Look at the duration of the consecutive sentence from the criminal history score of 1 for that assault, in this case, was 15 months. Subtract the consecutive duration from the time remaining on their term of imprisonment, and it tells you how much, subtract the duration at a criminal history score of 1 from the grid time. There we go. My apologies. Subtract the criminal history score of 1 duration from the grid time duration. So here we're subtracting 15 months consecutive duration from 27 months, the grid time, and we get 12 months. So now we flip the question and we say, does the defendant have more than 12 months remaining on their term of imprisonment? And I have found from my approach, that is actually the easier way to go. Because if they are out of the facility, the term of imprisonment remaining is 0. So there's nothing for the offense to go consecutive to. And so whenever we're doing presumptive consecutive sentencing, we always recommend that you give us a call so that we can talk to you about the real numbers that we have. But this is what we're going to be looking for. We're going to want to know what the time remaining is on their term of imprisonment when they come up for sentencing. so that then we can walk through and help you determine if that is appropriate. Because if it's not, it's a straight concurrent sentence, concurrent to the offense, the sentence they were sitting in prison for. The easier one to do is permissive consecutive, because again, the worksheets are completed to reflect concurrent sentencing, but the court chooses if they sentence permissive consecutive, and then they use the appropriate duration. So that makes it slightly easier than presumptive consecutive in that probation is not required to do any math in this situation. And that's my big thing. No math. When there's no math, I'm very happy. So for permissive consecutive sentencing, now the first question we ask is it eligible under the guidelines? Guidelines section 6 is the list of offenses that are eligible for consecutive sentencing. If the offenses are not on that list, and there's discussion of permissive consecutive sentencing, ask the attorneys to reach out to us, because when it's not on that list, it's a departure. So we may need to walk them through a different approach. Do your worksheet normally, though. But if it is on that list of eligible offenses, then the next thing that we want to do is determine if the presumptive sentence is a commit. And this is so easy to do because you're already doing the worksheet as concurrent. So if it's a stayed sentence, stop. It doesn't matter. Even if it's on the grid, we have to have or on that list, excuse me, we have to have both of those as a yes. As soon as you hit a no, you are done with determining whether or not permissive consecutive sentencing is eligible without departure. So when the answer to both of those questions is yes, then the court imposes the duration at the 0 column of the grid for all of the offenses that will be sentenced consecutive. I say it that way because it's important to remember that if the first offense is not going consecutive to anything, it's going to land on the grid time, and then sentence 2, etc., are going to be the ones that go back to 0. So the first one may land on the grid time, if not going consecutive, the rest of them at 0, but worksheets are always to reflect the concurrent sentencing. So what does permissive consecutive sentencing look like? The court, again, will impose the sentence found from the grid on the first offense. So here we have 2 criminal vehicular operation homicide offenses. The first one has a criminal history score of 2, so the presumptive is a commit for 68 months. That is then Hernandez, so we're still following all of those other policies like Hernandezing. Onto the second sentence, increasing the criminal history score to 3 and making the worksheet reflect 78 months. If the court's intention is to sentence the second homicide consecutive to the first, then they will impose the commit for 48 months, since that is what is reflected on the grid, and the ranges are available. So they can impose 41 to 57 months consecutive without departure. Sentence 2 consecutive to sentence 1, and those are then aggregated together. That's a really important thing, and it is a policy in the guidelines that the sentencing court should aggregate those numbers together, which creates then a new term of imprisonment and a new supervised release based on those durations. So in this example, when they're aggregated together, that's a 116-month sentence they're going to serve. 77 and a third of that in prison, and 38 and 2/3 of that off prison, or supervised release, rather, out of prison on supervised release. So again, it's pretty straightforward. I think the big thing that we always want to remember is that permissive consecutive goes back to 0. Presumptive consecutive goes back to 1. So think of it alphabetically. PE alphabetically comes before PR, so 0 before 1. There are other offenses that can be sentenced consecutive. These are ones where the grid time may end up being in a shaded box. The court can sentence them to a commit as a consecutive sentence without departure. And there are several of them on there, but the one that we see most often would be fleeing a peace officer in a motor vehicle. So I put together a little slide to show what that looks like, but ultimately, regardless of what they are, it's going to still follow the same track. So we're going to do the worksheets in offense order, Hernandizing, and showing concurrent sentences. So sentence 1 is a commit for 54 months. That goes to sentence 2, which is a stay for 17 months. And then there was also a third offense, a controlled substance 5th degree, that has a sentence of a stay for 19 months. So what does this look like? Fleeing a peace officer is one of the offenses that the court can execute the sentence on without departure for consecutive sentencing. And the reason is because at a severity level 1, it takes a significant criminal history, 6 or more, to get to the commit part. So if these were the offenses that were being sentenced, they would look like this. The court would impose the 54 months on the fleeing peace, on the felony DWI, and then they would impose a commit for 12 months on the fleeing a peace officer. So your worksheet would reflect the grid time, including the stayed sentence for the flee. It would be a stay for 15 months, I think is that duration. It would be a stay for that on the worksheet, but the court could execute that sentence and impose that flee consecutive to the felony DWI. So if they did that, they would take the commit for 54 months and the commit for 12 months, and they would run them together, and there's not really that 66 months and 1 day anymore, but it's entirely possible if it's an older one, that's what they might have done, is given them a year and a day. Those two are added together. Here we get 66 months, and then that gets divided into the 2/3, 1/3, 44 months, term of imprisonment, 22 months, supervised release. The sentence for that 5th degree controlled substance, it can still receive an imposed sentence, but it will end up getting sentenced concurrently. Because if the court were to try to sentence that consecutive, along with these others, it would be a departure. So that 5th degree just becomes sentence number 3, a stay for 19 months. Okay. That's consecutive sentencing. In giving you these policies, I just want you to see what it looks like, but to understand that oftentimes these are the ones in particular that need to be handled on that case-by-case basis because of the numbers involved and things like that. So With respect to consecutive sentences, just hold on to those in your back pocket so you know that if something comes up, you've got these two charts to look at. You can do that much. And then if it's going to be a viable option, reach out to us with the real numbers that we can plug in to a real equation for you. But now we're going to move on to sentencing modifiers. And as I was going through this, I realized that a lot of the sentencing modifiers that appear in this chart, this is a drop-down box that probation uses on EWS, Electronic Worksheet System, to indicate what modifier might exist so that the calculator that's built into EWS can do the math correctly to come up with the correct presumptive sentence. But some of the ones in that drop-down list are found in section 2C or section 2E. They're not necessarily just from section 2G, the modifiers. So I thought, why don't we just talk about these in terms of how they modify a sentence, as opposed to the idea that they are all modifiers under 2G. No, some of these live in 2C and 2E. So we're just going to talk about weapons, and then we're going to talk about a few of the more common modifiers. But we want to think about these in terms of modifying the presumptive sentence regardless of what policy they live in. So whenever we have a modifier that is going to create a sentence of more than a year, that's an automatic prison sentence. So any mandatory minimum of at least a year or more will be a commit. The duration for the sentence is going to come from the grid time or the mandatory minimum, whichever is longer. So that is a policy that you want to hold on to. The duration is always the grid time or the mandatory minimum, whichever is longer. That's what should be on the worksheet. So looking at two classes of modifiers here, because I do consider conditional release a sentence modifier as well, because it extends the length of the sentence, the supervision part of the sentence. But I went over that last month in the 2C, 2E Lunch and Learn. So if you're interested in conditional release information, hop onto that one from our website and you'll be able to see those slides. So we're just going to talk about weapons and some of these other modifiers that affect the presumptive sentence. The first one I want to talk about is weapons. Weapons is much more of a 2C presumptive, 2E mandatory than 2G, but it still modifies the sentence. But weapons have that additional component attached to them. After 2004, the Blakely v. Washington decision that came out of the U.S. Supreme Court said, pretty much in a nutshell, the court can no longer be the fact finder, that the defendant has the right to have a jury make the findings required to impose a sentence that is greater than, longer than what is shown on the grid, unless the defendant waives their Blakely rights or admits to the factors. There are ways around it that are slightly outside of our purview with this. So we're just introducing this Blakely idea because it led to other things in Minnesota, specifically one related to a weapon. What Blakely did was pretty much neuter the U.S. sentencing guidelines and say that they are absolutely advisory. And we were concerned about that because Washington State is the second guideline state in the nation after us, and they follow some of our stuff very closely. But luckily, a later case determined that Minnesota guidelines are not advisory, but the court can depart from them. Okay, so what does that mean in terms of this weapon, firearm, other dangerous weapons? There was a case in 2005, State v. Barker, and basically it was a fifth-degree drug offense, and there was a firearm, but the firearm was not within reach of the defendant. They ended up charging them under 60911, and he got an executed sentence for 36 months because that is longer than what the grid time would have been on a fifth-degree controlled substance. He appealed, and the court said that the sentence cannot be the mandatory minimum when that is greater than the presumptive sentence. And I believe at that time his presumptive sentence was actually a year and a day, maybe 13 months. So 36 months prison was a lot longer. And it said that in order for that to happen, the same Blakely-based procedure needed to be followed, which means there has to be a finding of fact that the weapon was an element of the crime. So that's a lot of legal stuff that the prosecution, the defense, and the court have on their shoulders. But for probation, it's often knowing whether or not that finding of fact was considered for the weapon so that you know whether or not you can use it. Because sometimes it is an automatic weapons offense. And other times, although it may be eligible to have a weapon included, there's no finding. So after a lot of this, the determination is pretty much the finding of fact is present when the weapon is included as the conviction offense, the defendant pleads guilty to the offense and admits to the use or possession of the weapon, or there is a finding by the court or the jury in a trial based on whether or not the weapon was an element of the crime. And unless that finding is made, no weapon is indicated unless it is one of the automatic weapons offenses. When we talk about automatic weapons offenses, we're talking about a few, 3, 4, 5 very specific offenses where the weapon is baked into the offense. So if you're convicted of that offense, it includes conviction of the weapon. Assault in the second degree is one, it's right there in the title, assault committed with a dangerous weapon. There are other offenses that say that, however, that are not weapons eligible. So we're looking here just specifically at those offenses that are called out as the weapon being an element of the conviction. So that would be certain first and second degree drug offenses. And for those, I'm talking about the ones that are aggravated based on the presence of a firearm, and the way that firearm presence is defined in statute is that it has to be within reach for the defendant to gain possession of, as opposed to it's in the trunk and they'd have to go unlock it to get it. That's not that aggravated or very specific first and second degree offenses. Assault in the second degree at either subdivision is automatic. Harassment with a dangerous weapon, along with felon in possession under either statute, and the felon in possession includes both firearm and ammunition. There is no separation in the statute where it's under one subdivision and clause for the firearm and another subdivision and clause for the ammunition. They are all together. And so when we talk about things like second and subsequence, Sometimes the weapon type matters, but when it's a certain person's, the firearm or the ammunition are both the same in that in that type of offense. They are treated exactly the same. And then drive-by shootings. That's the final one. Now, there is a statute under which the prosecutor can ask for departure. They can waive 60911, which is sentencing without regard to the weapon. That's the only way to get away from the weapon on these offenses. On the other eligible offenses that we see in subdivision 9, there would have to be a finding of fact. So one of the ways to recognize that they might not be considering that is if there is no 60911 in the complaint. I think that would probably be the first indication that there was no intention of doing a weapon for that offense and going to the finding stage. All of these have weapons offenses, which means all of these and any other offense where there's a finding that the weapon was an element of the crime carry specific mandatory minimums, keeping in mind that sentence will always be the mandatory minimum or the grid time, whichever is longer. So for their first dangerous weapon offense, that's a non-firearm offense. That's a commit for 366 days or the grid time, whichever is longer. But if they have a subsequent dangerous weapon offense, it's a commit for 36 months or the grid time, whichever is longer. And here, in those situations of subsequence, the court may not depart under 60911 subdivision 8, which allows for it. When you have a subsequent dangerous weapons offense, it means that you have prior history where there was a finding of fact that a dangerous weapon, non-firearm, was an element of the crime. So you have a current assault in the second degree with a dangerous weapon and no criminal history, that's going to be a commit for 21 months because 21 is longer than 366. But if they have a prior felon in possession, that's still going to keep them at the grid time because they have to have that prior same weapon type. Doesn't have to be the same weapon like knife, firearm. It has to be the same category. For firearms, the first offense is 36 months or the grid time, whichever is longer. And any subsequent offenses are going to be 60 months or the grid time, whichever is longer. And again, we have no departure ability under 60911 sub 8. Here again, the prior offense must have had a finding of fact that a firearm was an element of the crime, or it must be one of those automatic weapons offenses, the prior. So here you have an assault second degree with a firearm, that would be 36 months. If they had a prior assault second degree with a knife, their current offense would still be 36 months because it is not a subsequent under the statute. Same or similar weapons. And think of it more as same or similar category, not weapon type. And then felon in possession, it doesn't matter which statute is charged out. These are all persons not to possess firearm or ammunition. And as I said, the legislature did not break out firearm and ammunition into their own clauses. So these are all treated the same. So first and subsequent offenses are always going to be a commit for 60 months or the grid time, including the ranges, whichever is longer, and the court cannot depart from a subsequent offense under 60911 subdivision 8. So here we could have a current felon in possession of a firearm, and they have a prior felon in possession of ammunition. Their new one is a subsequent, and no departure would be eligible under this statute. So that is just a glimpse of weapons and their mandatory minimums, because they have these policies are much easier to hang on to. But we always have to remember that it is the grid time or the mandatory minimum, whichever is longer. That's the big thing here. And then we have a list of other sentence modifiers. Some of these are found in 2G, which is the modifier policies in the grid, in the guidelines, but some of them are under 2C or 2E, and I have noted that difference. But I want us to think about these in terms of sentencing modifiers as a whole, as opposed to only modifiers in 2G change the sentence. So approaching this from the most common sentencing modifiers that we encounter, the first one is a very specific first-degree drug offense that has the penalty statute 152.021 3 C cited. When that is the penalty statute, that is the modifier that gets selected so that the calculator removes the lower range as an eligible sentence, and it makes the lower range the same as the presumptive sentence from the cell that they land on the grid. Make certain that you either add that modifier for probation and EWS, add that modifier, because when that modifier gets missed and the court imposes a sentence below that duration, that's going to be a departure. So you're going to always need to add it. But if 3 C is not the penalty statute, don't add it. You get a pop-up on EWS that says the penalty statute may require an additional modifier. Make certain you only apply it when the modifier is 3 C. Attempts and conspiracy under 60917 and 175 are modifiers that reduce the sentence by half, but it cannot go below than any mandatory minimum, and it cannot go below the felony level of a sentence. 365 days if they're being sentenced now, 366 days if they were sentenced back before July of 23. The sentence might be 18 months, and then you apply the attempt to it. That sentence is then 12 months, because 12 months is the minimum felony sentence. If the court were to say, okay, attempt reduces the sentence by half, it's an 18-month presumptive sentence, half is 9 months, we're going to impose a 9-month presumptive sentence, they have changed that felony to a gross misdemeanor by the imposition of that sentence. So while we say reduce by half, we keep in mind the mandatory minimum and the presumptive minimum sentence that a felony can have. Same thing is true with conspiracy, but we want to watch out for the Chapter 152 conspiracy. That's 152.096. That one makes no change to the presumptive sentence. So when that is the conspiracy statute, It's just cited as an additional statute and no change is made to the sentence. So always verify if you have a drug offense that says it's a conspiracy, verify which conspiracy it is. Burglary of an occupied dwelling. This is burglary under 609.521 parent A. So the severity level 6 burglary specifically, if they have a prior felony burglary, any level, first, second, third degree, it has to be a felony, and it can be decayed, but a prior felony will make a current burglary of an occupied dwelling a presumptive commit for the grid time. A drug offense that is a subsequent, this is another one that lives in 2C, but there are modifier requirements when working with the electronic worksheet. A drug offense that is a subsequent has a different idea now than it did before 2016. So we're going to focus just on the August 1st, 2016 policy, since we're about a decade away from that. We see very few pre-26 offenses, but for post-2016, it's a current first or second degree drug with a prior first or second degree drug conviction that occurred within 10 years of the expiration date of the prior to the date the current offense occurred. Let me say that again. The prior expiration of the entire sentence, doesn't matter if it's probation or if it's prison, it's the end of the entire sentence, 10 years to the date the current offense occurred. So it's very possible to have a prior drug offense in criminal history that is a first or second degree on a current first or second degree, but it's too old to apply the subsequent. So always keep in mind that 10 years. Failure to register is another one that is a modifier, but it is solely based on statute. And that is 2431665 parent C. That is the statute that says a mandatory minimum of 24 months applies when there is a prior failure to register. Unlike the drug offense or the DWI offenses, there's a policy in guidelines that does not identify what statute they are charged under, but only identifies that this is the current offense and they have this specific prior offense. Failure to register does not do that. There is no corresponding policy in guidelines that says first failure to register with a prior failure to register is an automatic subsequent. That doesn't exist. So we're looking for that statute 5 parent C. And there is an additional statute within those penalties for this, 5 parent D, which allows the court to sentence without regard to the mandatory minimum. This may be one where the lack of that statute is them saying they're going to sentence the offense without regard to that mandatory minimum for a subsequent and just treat it as a first-time offense. That's subjugation. That is subjective on my part. That is thoughts I have late at night when I'm thinking about how to explain these things. And that's kind of where I've landed on that one. So always, much like the first one, always make sure you have the right statute listed to apply the modifier in those cases. And finally, burglary in the third degree, failure to, wow, I'm just going to stop for a minute, take a deep breath and say felony DWI with an applicable prior. The applicable prior has to be a felony DWI as it's defined in statute, or a prior CVO or CVH offense under the drug and alcohol statutes. And the reason why I say it is a prior as defined in statute is, without getting too much into the weeds, there's a difference here in the felony DWI statute with respect to how to use out-of-state offenses. And so I'm just going to say you're probably going to apply this when the current offense is a Minnesota offense and the prior felony is a Minnesota offense. If you run into it in another situation, like using an out-of-state offense, reach out to us. So again, I want you to go to 2G to look at what all of the modifiers are, because there are a lot that we haven't talked about because they just don't come up very often. And so rather than giving you a lot of information to hold on to, let's give you information that is applicable in your everyday job. The last modifier that I want to touch on as we close out today's Lunch and Learn, and if you have any questions, you're welcome to type them into the chat. Hopefully Devontae's there checking it, and I think he is. Thank you very much, Devontae, for that. But if you have any questions, get them in the chat or raise your hand so that we can make sure that they get answered. The last thing I want to go over is the second or subsequent severe violent offense modifier. So for ease of the name of this, we call it the SVO, severe violent offense modifier. Just like we have a list of offenses that are eligible for consecutive sentencing, we also have a list of offenses that are considered to be severe violent offenses by the commission. This came up in 2019, so if you have a pre-2019 offense, you don't have to worry about this. This is 2019 and beyond. The current offense is a severe violent offense from Section 8, and they have prior conviction or convictions for offenses found in the SVO list, Section 8. And again, just like every other modifier we apply, the conviction has to be imposed before the current offense was committed. So the addition of time is based on the number of severe violent offenses they have, prior severe violent offenses. If they have one, it's going to add 12 months. If you have an attempt or conspiracy on the current offense, the duration would only be 6 months. If you have 2 prior SVOs, it's 18 months or 9 months for that attempt or conspiracy. And if there are 3 or more, it's 24 months, 12 months for the attempt or conspiracy. The worksheet, again, will always reflect the SVO modifier. But if the court is going to impose consecutive sentences for offenses eligible under the SVO modifier, they are not going to apply that additional duration from a 0 criminal history score for the consecutive duration. They're just going to stick to what's in the box and not add any time onto it. The severe violent offense list, again, in Section 8, whenever we're looking at whether a CVO is applicable, you've got to verify that you have the right statute number. Because if you don't, it may not be eligible. And the one I want to point out most importantly is that assault second degree. It has to be under subdivision 2, the dangerous weapon, substantial bodily harm, to be an eligible SVO. but the rest of them, as you can see, are here. The other thing to keep in mind is a prior SVO conviction is not the same as using a prior in criminal history. So we have these two policies in 2B1D, parent 1 and parent 2, that explain how to use Hernandizing exceptions in prior criminal history. So the current offense has a Hernandizing exception, and it's going to come back later to be a prior in criminal history. Remember that under the single course of conduct, multiple sentences involving a burglary, kidnapping, or meth fentanyl offense, only one prior is used in criminal history, but there may have been more than one conviction and sentence, as is the ability to only use two priors in criminal history when it's a single course of conduct, multiple victims. They may have had 5 offenses that were convicted, but only 2 were carried in criminal history. All 5 of those count as SVO priors. So always keep in mind the difference between prior criminal history and prior conviction for the SVO modifier. And our last, to take us right up to 1 o'clock, is attempt or conspiracy to commit first-degree murder. This is its own offense. It is given a severity level 12, which does not exist on the sentencing grid. That 12 is assigned because we have to collect completed first-degree murder offenses. We have to track those. Worksheets are required. So for that reason, and the fact that this is not on the grid, it is assigned a severity level 12. And then this is the mini grid contained in 2G12 that tells you what the presumptive sentence is, not exceeding 240 months, which is half of the life sentence, but it also comes from statute. Sometimes you just gotta accept that the maximum for an attempted or conspired to commit first-degree murder is 240 months. So that brings us to the end of our last Lunch and Learn involving the individual policies, 2B1 through 2G, or 2B through 2G. We went through all of them. As Devontae pointed out, he has been so great about getting these up on the website so that you can go back and review any of them, as well as the slide deck. If there's somebody in your office, if we've got some attorneys on the phone or some judges and judicial staff that are on the phone, and you want to ask your colleagues to also look at any of these lunch and learns, we also have CLE credits for those on-demand viewings, and you just have to reach out to us to get that. So that brings us again to the end. We'll open up the floor for any questions if you have any, but otherwise, we are done with today's session. So, trying to pull up my camera and I'm not being very successful.
There's one question in the chat if you could help me answer.
I can. Let's look at that question. When sentences are aggregated, is it that question?
Yes.
When sentences are aggregated, do they both have the same expiration date when adding them as criminal history on a future worksheet? Yes, because that aggregated sentence is both of those together and then ending at the same time. So I would say the answer to that is yes. I love how folks have jumped in and asked questions along the way, and Devontae's there to catch them. So that's it. If there are no